Welcome to our program. It's part of our navigating series, and today we are navigating inside the SEC. As I said, my name is Rebecca Fike. I'm a partner here in our Dallas office. I went to undergrad at the University of Texas, Hookham, and University of Chicago Law School. I started my career at Vinson & Elkins in 2008. I actually started in our corporate practice group because I loved the corporate law and securities law classes in law school. And I thought, if you like corporate law, you should be a corporate lawyer. I quickly learned that no, corporate lawyers, apologies to all of them online, don't do a whole lot with the law. They're not looking up cases, you're not writing, all the things that I had loved in law school. And so I quickly realized I was in the wrong place and on the wrong floor, and I switched to litigation. And I focused on corporate and securities litigation. In 2012, I had the opportunity to go to the SEC, and I joined the Division of Enforcement in the Fort Worth Regional Office. I was there for 10 years. I tried to add it up, I think at least 60 cases. I brought 14 enforcement actions, including a few what we called top 5 national priority investigations and some front page cases. It was great work, a lot of fun, and I learned a lot about the SEC, which I'm hoping all of the public aspects of which I am looking forward to sharing with you today. And I rejoined V&E this year in February as a partner. So our agenda for today, we're going to talk about the SEC structure. A lot of people, depending on your practice area, know of certain divisions and offices, but not everyone has kind of that fulsome view of how it's set up and how it works and how those interact with one another. We'll mostly focus on the Division of Enforcement, since that was my home for a decade. And I want to spend a good amount of time talking about how an investigation begins, how and when and why it goes from an inquiry to an investigation to potentially an enforcement action, as well as the role that whistleblowers play in that process. We're going to talk a little bit about parallel investigations, working with other civil and criminal agencies, which the SEC does often. The rulemaking, which, if you're paying attention at all, is a very robust part of the commission at the moment. And then kind of end with some things to consider, times to reach out to your, friendly SEC defense counsel, to your corporate counsel. And some of this I've already realized in my months of being back out, there's a lot of opportunities to bring in some advice on the SEC side, even when a deal is still being transacted, when a board is first coming together. There's a lot of things you can do proactively that, should the SEC ever take a look at your organization, you're in the best possible position. Because obviously you should call one of us if you get an SEC subpoena. So we're going to try to talk about some other situations where it might make sense to reach out. And then we will end with questions. Next slide. So we will not be going through the details of this, but I did just want to show that the SEC is a large and complex organization. There are many offices, there are 6 divisions, there are a number of regional offices, and they all interplay and interact in different ways. And while I was in enforcement, and that's what a lot of people who do what I do know about, there's actually a vast array of other kind of duties and responsibilities and roles that the SEC plays. And also just to note, almost all of these, if you go on the SEC's website, have a contact us or a public facing page. And that can be really helpful. I mean, sometimes when you have, an SEC related question, there might be an office that speaks directly to that. And they have ways to reach out and ask questions about, interpretive guidance for a rule or other things. Next slide. All right, I'm going to spend a little bit of time here. So we're going to talk about the 6 divisions of the SEC. The divisions are generally larger, if not in size, and kind of in imprint and impact than the offices. They're in alphabetical order, so I'm not showing any favoritism, but we'll start with the Division of Corporation Finance, or generally referred to as CorpFin. Their mission is to ensure that investors are provided with material information to make informed investment decisions. So they are looking at, and in fact, if you're a corporate attorney, CorpFin might be who you interact with the most, whereas on the enforcement end, we very, very rarely interact with them. But what CorpFin does is periodically reviews certain filings. There's some types of companies or types of public offer, well, they're always going to look at an IPO document, but there's other deals that they'll periodically review, and they'll review certain Ks, and they have their office divided into areas of expertise. So you have your, oil and gas team, you have your construction team, you have people who their job is to review the filings of this type of company, and they are generally very knowledgeable about what they do. There'll be there's a comment letter process, which again, generally a corporate transactional type attorney will interface in that side, and that's where CorpFin is asking questions about a filing that you've submitted, and there's a back and forth. They might be saying, please provide more information on this, or, change it to this format. They love a chart, or, update this here, or compare to this, or reconcile these two parts. I mean, they will really dig into your filing. If no one else ever reads it, I can assure you that CorpFin does. They also put out public guidance and bulletins that can be really helpful, especially when there's new requirements about public disclosures. And then CorpFin does make referrals to enforcement. So sometimes that'll come up through the comment letter process. If they feel like they're not getting good answers to a question that they believe should be answered for investors, they will send a referral over to enforcement. And those generally, and we'll get to kind of the enforcement process and how a case gets opened, but a CorpFin referral generally does move to the investigation phase, because usually CorpFin is pretty knowledgeable about this issuer, they're knowledgeable about the industry, they've had back and forth already, and so their doubts usually have some substance because they've tried to get answers. Then it goes over to the enforcement division. And also sometimes within enforcement, if CorpFin is reviewing an issuer, they can look to see if there's an active enforcement investigation, and they might reach out to enforcement there and say, is there anything we need to know as we review this filing? So there's not a ton of communication between the divisions. They have pretty separate roles, but there is some. Then the next division is DERA, which is the Economic and Risk Analysis Group. It's actually a very small division. I'm kind of surprised, actually, they are a division, but they're just incredibly smart. And so I think we gave them all this title. It's a group of PhDs and economists. They're used by everyone. So enforcement will use DERA to figure out, corporate benefit analysis, help, not the disgorgement calculations, because those are pretty easy, but to the extent you're looking at maybe a penalty because you're saying that, the company's false information affected the market in a certain way, DERA is the one who's running all those analytics that will support your recommendation. They also serve the commissioners and their rulemaking. So figuring out the economic impact of various rules, that's all going to be DERA. They also do a lot of public speaking. They speak at conferences, they speak to various industries, and they put out publications and articles and other things. But they are all generally PhDs. And then the Division of Enforcement, which we will spend plenty of time with, they conduct investigations into possible violations of the federal securities laws, and they are the ones who file suits on the commission's behalf in federal court or with an administrative law judge. We'll come back to them. And also, I will just note, in enforcement, as an attorney in enforcement, my client was the 5 commissioners. So an enforcement attorney is not empowered to act on their own. And that's why any public facing action must be approved by the commission. And then it's in the commission's name that you are filing an action. So that's kind of the way to think about the authority that you have within the Division of Enforcement. Next is our exam division. They used to be an office. They were the Office of Compliance, Inspections, and Examinations, and they got an upgrade to a division just a little while ago. It doesn't matter to anyone unless you're within the SEC and the exam enforcement rivalry. They protect investors through strategies to improve compliance, prevent fraud, monitor risk, and inform policy. So unlike enforcement, which generally needs a tip or a referral or a reason to think there's a problem to justify opening a matter, exam does periodic examinations of regulated parties. So if you're, a broker dealer, you're an investment advisor, there's all kinds of different categories. Exam can have scheduled exams. They can have surprise exams. They can show up, knock on your door, say, bring me to your chief risk officer. They're going to want to talk to me, and then bring me the following files to make sure that you have everything up to date and that you're following the various procedures that you need to do. They also make enforcement referrals. So if they find deficiencies, some deficiencies can be corrected within the exam, but if they find something they think is larger or the root of a larger problem, or they're not getting answers, then they will refer that out. Exam also publishes their priorities every year on the website, and that can be a really helpful way to look at if you fall under the regulated entity category as to how likely it is you might hear from exam in a particular year. Investment management is next, or IM. They administer the Investment Company Act of 1940 and the Investment Advisors Act of 1940. These are very specific, fairly complicated acts, and IM is the in-house SEC expert on that. They develop policy for investment companies that would include mutual funds, money market funds, BD companies, variable insurance products, and more. They really the idea behind them too is you're focusing on that Main Street investor. IM is looking at the vehicles that your average retail investor is investing in for their future, their retirement, their kids' education. And that's what IM is helping to regulate. IM is also the in-house expert for those matters. So if you in enforcement, because IM does not do enforcement actions. So if you in enforcement are looking at an entity that would fall under IM's jurisdiction, someone from IM will definitely be talking to you throughout your investigation. There's a lot of rules. They are very detailed, and you want a subject matter expert on the line. And finally, we have TM, trading and markets. They regulate the major securities market participants, including broker-dealers, SROs like stock exchanges, FINRA, clearing agencies, and transfer agents. They're another one that often will serve as an advisor or a subject matter expert on an enforcement investigation. They do have on their website a check your investment professional link, which, just to tell your family members, especially your senior family members, that can be a great resource if someone is trying to get you to invest with them. FINRA also has a broker check option that can be helpful there. And TM also has public-facing contact information for questions. We are not going to go through all of the offices. There are a lot. They are important. I worked with almost all of them while I was there. One, just to kind of call out, the Office of the Chief Accountant, which we have several accountants in the room. They are a really critical one. They help interpret accounting guidance for what is the correct, form or answer for any U.S. public filing. So many people can maybe disagree what GAAP means in a certain situation, but what the chief accountant says it is what it is for the purpose of that public filing. And enforcement also often gets assistance from them. There's also Office of the credit ratings. There's international affairs, so that way enforcement can get bank records and other documents outside of the U.S. There's an operating officer. There's an ethics council. And then all of the regional offices fall under the office category. And then finally, the client, the head of the SEC, are the 5 commissioners. They are all presidentially appointed and Senate confirmed. You may not have more than 3 from any one political party. Generally, the way that then works out is that there are 2 Republican appointed and 2 Democratic appointed commissioners, and then the chairman is whatever political party is in power at that time from the executive branch. So President Biden appointed Chair Gary Gensler. We have Commissioner Peirce, who's a Republican appointee. She came in from the previous administration. Same thing with Commissioner Crenshaw, who is a Democratic one. And we have 2 brand new ones who just got confirmed in the last month, Mark Ueda and Jamie Lizarraga, and they just started. And you'll kind of note the way their terms work there, even though Commissioner Ueda just started, because he's taking over a previous term that hadn't ended yet, he steps into that term. So there will actually be a new one in 2023, which is shockingly just a year away. And next slide. All right, the question I will say I've probably gotten the most since I came back out to private practice, which is, how does an enforcement action begin? And how do if I'm a company or an entity, know if something that is happening in my company is going to become the subject of an enforcement action? The main answer of which is you don't, but I can tell you how the process works. So enforcement opens investigations for 3 different reasons. There is a tips, complaints, and referrals portal on the SEC website. There's also a phone number that investors can use if they have a complaint, and you can still send in a snail mail complaint, which does still happen. And so on there is where you're getting everything from a competitor is mad and is submitting a complaint about a company to an investor who's not receiving their returns. It can run the gamut. They get thousands of them. And there's a whole team at the SEC whose job is to triage those TCRs, is what we call them. What that team will do, they look at every single one, as long as it's legible and they can figure out what the person's talking about, is they do kind of a kick the tires kind of check. Is this even a company? Do they exist? Can we find them? Do they have investors? Is there any reason to think there could be an issue? Are they putting out press releases that could be false? Have they had a recent spike in their market price? Just kind of looking of, how much validity does this likely have? If, there's a lot of support there for wanting to ask some questions, that can go right out then to a referral to enforcement staff. Other times it might kind of be in a wait and see. We've received this one complaint, we're kind of looking to see, and let's say then over the next few weeks you get 2, 3, 4 more. Okay, now we should probably refer this out. So that also happens. And there's others that just kind of close. They always stay in the system. So if you get more complaints later, that can show up. But there are plenty that do not get staffed out. And then as far as the staffing goes, it's a little, you kind of jockey for position within the enforcement division. Generally, it will go to the region in which the company or the individual is located. That said, some regions have developed expertise in certain areas. Fort Worth Regional Office is the oil and gas fraud expert. So for better or for worse, we got most of those. There's also certain staff attorneys who develop expertise. So we have some who fairly early on figured out what cryptocurrency was and why it mattered. And so when things like that would pop up, Bitcoin and other things, it would get routed to them no matter where they are. There's also a way to kind of, I'll get to that, I guess, in a second. So the other way you can get an investigation is through a whistleblower. A whistleblower is different from a TCR. A whistleblower is a report that you submit through the office of the whistleblower. It is treated anonymously. So even if you submit it with a name, the staff treats it anonymously. Usually people who submit whistleblower complaints have counsel. And so staff just interacts with the counsel and the actual witness remains unnamed throughout the investigation. Those are handled differently. They get a little more of a closer look. Someone will always reach back out to a whistleblower to verify information and see what should happen with it next. They get staffed out in a similar way. And then enforcement staff can open in investigations. So, I had one that turned into a really large investigation that we opened because of an article in the New York Times. Or you might see a spike in a stock and open something. Or a friend of yours says something and you're like, that seems weird. And so you might try to go open something. You can also get a self-report from a counsel that you've worked with in the past. So if you are a good attorney and they think you handle everything professionally, you might have a lawyer at a large law firm who has a client who self-reports, and they'll say, I really think you should self-report this to the commission. I have a staff attorney I have worked with in the past. I think she'd be a good person for us to reach out to, and I could take that call directly and open up the matter. And in that way, you get to plant the flag, call it yours, and then when the home office in DC eventually hears of it, they can't take it away because that's usually their goal for any case that might be big. I shouldn't say that. There's probably people from the home office on the line. Everyone at the Division of Enforcement is pursuing the same goal. But there are ways you can be a little bit entrepreneurial within the Division of Enforcement, which is also ways now in private practice, you as a client or a company can exert at the start potentially some control over where your investigation ends up. And then the referrals piece of that is referrals from other agencies. So the Department of Justice may have opened something. They feel like there's substance there, it involves a security issue. They will then often refer the matter to us and we will pursue that matter parallel. We might get referrals from FINRA, from other SROs that don't have enforcement authority, from state regulators because they realize it's a federal and cross-state issue. IRS will refer things over. Postal refers things over. I got stuff from the JAG a couple times in the military. Referrals can come from anywhere. And then the stage of the investigation, the MUI, we call it, matter under inquiry, which no one says, it's just MUI. That's the opening. You don't need much to open a MUI. You need a name, general date-ish, and that might be it. That's your, I'm gonna look around, kick the tires. You can reach out to the company. If you've ever represented someone or you yourself have received one, it will just be a letter. It won't have a subpoena attached, but it will say, you know, the Securities and Exchange Commission is conducting, usually they use the word inquiry in it, and request the following information. It's voluntary at that point. You should probably do it anyway, because refusal to voluntarily turn something over is great grounds to go get subpoena power. But oftentimes that's where you've received, and maybe someone's received a tip or a complaint, and they just want to verify what's going on. Or sometimes there might be a filing, an 8K or something about a CEO leaving. You might get a letter from the SEC saying, hey, what were the circumstances of that? And, is there anything we should know? So those are all in that stage. It's very easy to close a MUI. It's just another sentence. Or things can convert to an investigation, which they generally do after a certain period of time if it's still open. An investigation, at that point, you can request and receive formal order authority, which is what allows you to send a subpoena. It also allows you to request bank records. Investigation, you'll know it's an investigation because when you have the case or the investigation name and number, every office has a different 2 or 3 letters that is their office. So in Fort Worth, it would be investigation in the matter of X, FW dash, and a number. It's MFW if it's in the MUI phase, and the M drops when it's in the investigation phase. And then there's, then after investigation, you can go to closing or you can go to an action. It could also, depending on the defendant or the entity involved, have different results for different people. Just a note on the bureaucracy. There's formal orders. Those are a pretty substantive memo. You really do need to have some good support to convert something to an investigation and get formal order authority. Those are also approved by the commission. It's delegated to the director of enforcement. He can approve them, but the commission can also review them. There's quarterly updates. If you are involved in an SEC investigation and haven't heard from your staff attorney in a while and you hear from them right before the end of a quarter, that's why. There's Wells requests, which is something that you get if the enforcement has decided to recommend an action against you. They will send you what's called a Wells notice. That is an kind of an informal, unofficial procedure that has become both formal and official, that it was named after the chairman at the time, or maybe it was the head of enforcement at the time when they started doing this. But it basically says, hi, we are planning to recommend an action against you based on the following for the following charges. And you have an opportunity then, prior to an action actually being recommended, to push your case, push your defense, and explain why they're wrong. It can be a really valuable time, especially because sometimes you have people who thought they were in the witness category and find out pretty late they're actually in the defendant category. And so they've been cooperating as a witness and maybe not thinking about their own defense. Usually good counsel will help with that all the way along the way, but sometimes it's a surprise. It can also let you, as a staff attorney, your view is pretty narrow. And so sometimes there might be some big piece or some kind of context they've been missing that Wells notice gives you a chance to say, oh, wait, you're not understanding, and kind of pulling back. The director of enforcement approves the issuance of a Wells request. So you need a pretty good reason to not then charge the person. You've now involved some higher ups who have signed on to your theory. And so as defense counsel, your audience is not just the staff you've been working with, it's all the way up through the director of enforcement. And you can speak to a lot of different ways to help with your defense there. There's the hub where every single case is tracked. So you can always look up and see if there were things opened, for someone else during a period of time. And there's case closing memos, which our job as defense counsel is to help as much as possible with drafting that, help give them all the support that they would need to close an action. Next slide. There we go. Whistleblowers. So I asked some of our corporate partners, what are the questions that you get the most from your corporate clients about the SEC? And every single one mentioned whistleblowers. How does it work? How are they triaged out? How do we know if we think we have a whistleblower, if the SEC will actually come? Again, it depends. I can't tell you that, but I can tell you how the process works. So as we mentioned, tips are submitted through the office of the whistleblower. They are staffed out. The anonymity is safely guarded. Names aren't included even in our own internal updates. It's just referred to as whistleblower. We'll give them a number if there's more than one, but that's taken very, very seriously. But there's been a huge increase in whistleblowers, as I'm sure most of you know, because of the bounty program that was developed as part of the Dodd-Frank Act. So you can read all about each year's results of the whistleblower program. They produce a report to Congress every year, which you can find on their website. It's really interesting. It talks about the numbers, the stats, and all of that. I looked up, and in the fiscal year 2021, the Office of the Whistleblower received 12,200 whistleblower reports. And in connection with 86 covered actions, the commission ordered awards of $564 million to 108 people. So you can make a lot of money being a whistleblower. Some of the awards were over $100 million. The award is 10 to 30% of the money collected in the action. The money does have to be collected. So oftentimes we're charging individuals or entities that are bankrupt, and you still do it for other reasons, but you're not actually collecting money. This has to be of money collected. The Office of the Whistleblower assesses how much a potential whistleblower should be awarded. And they look at things like the significance of the information provided, the assistance the whistleblower provided throughout the investigation, like did they continue to help beyond the initial submission, whether or not there was law enforcement interest, like did this then kick off a criminal investigation that helped the DOJ, and whether or not the whistleblower participated in the company's internal compliance program. That's considered a positive factor, the fact that you did report internally. Negative factors are if you are yourself culpable in the behavior, which happens a lot, an unreasonable reporting delay, something bad happens, and like 18 months later, you're like, I might make some money off of that, and then go report it. That's less helpful. And if you have interfered with internal compliance and reporting systems, and maybe just skipped everything and gone directly to the SEC. The whistleblowers are responsible for making a timely application for the award. So the office puts out what's called a covered action, any action that could result in a whistleblower award. You see that and you apply. I would note, and we'll talk a little bit on the next slide about what companies can do if they suspect a whistleblower. Not every whistleblower submission becomes a case. I mean, just kind of the same thing as a TCR, because sometimes we'll get a company that has a disgruntled employee, they've done an investigation, they really feel like they've done everything right, and they're still worried. Not that obviously you can guarantee anything, but it is not that every single of these 12,200 whistleblower commission tips became an investigation. There's still corroboration and triaging that happens. And then some company considerations if you suspect a whistleblower. Document everything. Especially if you're suspecting in the category of disgruntled employee or something else, but make sure that you have a fulsome and complete file of anything that is helpful to you and support for any of that. Consider a self report if either you think the allegations the whistleblower might make would give rise to an investigation, whether true or not. It can be worth, and sometimes happens, a company reaching out and saying, hey, we have this person, I think they're going to come to you and say this, here's why that's not true. Sometimes that is in their best interest, but we'll talk about self-reporting in a second. If it makes sense, conduct your own internal investigation, follow your own procedures. That does a lot. You don't have to reinvent the wheel. If you have a robust compliance program, just follow it. Do what you're supposed to do. Show that you had the procedures, show that you followed them, and document it. There is a rule, Rule 21F17. It is my personal favorite rule. I brought the first ever case that enforced it, and John Wander of E&E was the defense counsel on it. And I still got to come back here anyway. But it says, no person may take any action to impede an individual from communicating directly with the commission staff about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement. And what happened in KBR is there was a confidentiality agreement that I believe was part of an internal investigation, but I'm not certain. It's in the public information about the case. But in there it said you must first report to the general counsel's office prior to reporting to any government agency. That is considered impeding communication because you're saying before you go to the SEC, you must go here first. And that is not allowed. And in that case, there was not any retaliation against a whistleblower that the investigation found. There wasn't, that kind of plus factor. The existence and use of that agreement was enough. And most companies changed their agreements after that case. But just note that rule is still on the books, still enforced. And oftentimes in enforcement action, you may be asked to provide those agreements so they can look at them and see what's in there. As far as whether you can terminate a whistleblower or any of that, I'm not touching that. That's your employment lawyer in conjunction with your corporate counsel and your SEC counsel. I would say, again, documentation is your friend and exercise caution there. Next slide. So here, I got to doctor up one of my favorite little memes. Just a moment of noting, having been at the SEC for 10 years and how I think understanding the workload can help you in private practice, help your clients the best. So this is speaking directly to the Fort Worth regional office, for example. There are 5 what's called assistant director groups. There's an assistant director who manages the group. Generally, there's five lawyers. They're the staff that you always hear referred to. There's a staff accountant who assists on any investigation that requires an accountant's knowledge. I miss my staff accountant dearly. And there's one paralegal that the group shares. Within that, each staff attorney has between 5 and 8 cases. Cases can be huge. Almost none of them are small. And they're all on different timelines, different stages of investigation. You could be heavy in testimony and deep document review. That is one of your cases. And there are always others. And generally, it's pretty rare that multiple attorneys would be staffed on the same case. So even a really big, really important case usually just has one attorney working on it. And there's very rare cross-staffing or cross-group staffing, although you can reach out to other divisions for help or expertise. Usually one attorney runs the case. And what's helpful for that on the private side is that you can build a rapport with your investigative attorney. You're usually going to see the same name the whole time. They're the one you're corresponding with and working with, and that can be in your favor. There's also a trial group in the regional office that has its own assistant director and then trial attorneys. They usually get an extra paralegal or two. But again, it's not a huge team compared to usually the defense side by the time you get to trial. Now, of course, while we don't get contract attorneys or anything like that, you do have some resources in that you can request brokerage records, bank records. Very rarely you might get a contract attorney. That's very exciting. We do have the SEC has other in-house experts. So in Fort Worth, there was a geologist who was a full-time employee and would help go through oil production reports, everything the Texas Railroad Commission puts out, things like that. So there is some in-house expertise, but it can be really helpful if you can develop a cooperative, you're still advocating for your client, but you're developing this cooperative relationship with investigative staff because they kind of need you to help them. They cannot investigate your entire organization. There is not time. And so to the extent that you can build a rapport and they can have some trust in you as a lawyer, and the company has done some of its own investigating or has closed certain avenues and feels certain that this did not lead to anything or this didn't, you can really work with them to help the work the company did kind of go into the investigative attorney's thought process and file. And you may need to support it and show proof and everything, but generally as staff, it's very helpful when the company has done a good internal investigation. And that can be really helpful with cooperation later. Next slide. We already mostly talked about this, but this is just kind of the life cycle: MUI, formal order, investigation, settlement or wells. Oftentimes you might settle without ever sending a wells. Like you'll just have a conversation with staff where they're saying, here's what we think you did wrong. And you might be like, yeah, and then you work to a settlement. There's an action memo that staff creates and submits to the commission so that the action can be voted on. That's true for settlement as well as litigated action. So settlements have to be approved also. And that's something to keep in mind on the private side. Just because you and staff have reached an agreement and you think it's fair, the commission may not. And depending on the chair at the time, depending on the makeup of the commission, because commissioners don't all leave at the same time. So you might have one who's left, and now there's an imbalance of the political parties, of the various views, and that can really affect whether or not a settlement will get approved. So it's something to keep in mind. And you then make your recommendation as a staff attorney directly to the commissioners at what's called a closed commission meeting, and the commissioners vote. And if they approve it, you get to file it. If they don't, you don't. You also need commission approval to file a litigated action, to approve any settlement in a litigated action, to amend charges or relief sought, because again, you, even as a trial attorney, cannot act for the commission. You can only act on behalf of them, and they have to vote on what you do. Next slide. Parallel investigations. Again, why highly encourage engaging counsel early. Because as the Form 1662 that you will get with any request, informal or not, from the SEC, that I don't know if anyone actually reads, it says we can and do share information with other civil and criminal agencies. As the SEC, there's very little restriction on what the SEC can share with a criminal agency. And that is often the way information flows. The criminal agencies can share information with the SEC, and they often do, but they cannot share any grand jury materials. So that's covered by the secrecy provisions under 6E. If it's from a grand jury, subpoena, or anything like that, the criminal agencies cannot share it with the SEC. They can't even mention that it exists to the SEC, which can be frustrating when you're the SEC. But when you're the SEC, everything can go to the criminal authorities, and often does. And so if you, let's say there's testimony, it's civil testimony, and you create, there's a transcript created, that entire transcript can go to the DOJ. So anytime you're talking with the SEC, you have to keep in mind that this could and maybe will, depending on the subject matter, be seen by a criminal regulator. Same thing with bank records. It's easier for the SEC to get them than the DOJ. So usually we send those over if it's relevant and needed. The DOJ can share search warrant returns as well as voluntary productions. I'm trying to think. SEC does also often refer things out too, just like we get referrals, we send them out. So there is DOJ, but sometimes in an investigation, IRS might come up. You look at something that looks like securities fraud and you realize it's actually tax fraud. So that, luckily you get to kick over to somebody else, but that goes to the IRS. You also work with, so the DOJ, lucky them, get to have their own investigative agencies they work with. So the FBI or Postal. So U.S. Postal inspectors often also get staffed as the investigator on a criminal investigation. So oftentimes there's a parallel case. It's DOJ, someone's either from FBI or Postal, and then the SEC. Whereas SEC is both enforcer and investigator in one. But you'll often, if you have like a joint interview, that's all the people on the government side of the table. And just a note, wasn't really sure where to stick this, but I think it's important. It used to be that emails had all the juicy stuff. That was the really good thing when I was an associate, like in 2008, where you'd find all the like offhand remarks. People now are pretty good about their email. I think email feels formal. Texts and WhatsApp is now where anything interesting in an investigation is something you got from WhatsApp. So just kind of a note to attorneys, clients, and all, that those can be received. Those companies and entities themselves can be subpoenaed. So you can subpoena Apple, for iCloud data, things like that. You don't have to get the physical phone. Sometimes you do, but there are times where even if you have not turned over your phone, you may be surprised to find in testimony that an exhibit is a whole line of your chats with someone. So just to note. Next slide. Oh, and also just to note, it's okay, you don't have to go back, but if a person asserts the Fifth Amendment privilege, so the privilege against self-incrimination, you do have that in civil cases. However, that negative inference from not answering a question can be used against you. So if you assert the Fifth in a civil investigation, fine, you don't have to answer the question, but I can write, when asked, he refused to answer, or, he asserted his, privilege under the Fifth Amendment, whereas that's different in criminal. And also just the note that corporations do not have Fifth Amendment rights. Just something I had to explain frequently. So on the rulemaking side, I won't spend too much time on that, but just to note that despite being in the Division of Enforcement and thinking that the commissioners, they were my client and they should be really paying attention to all of our investigations, very small part of what they do. Rulemaking is a huge part of what the commissioners do. They're looking at, what all these other divisions and offices are doing. There are rulemaking mandates under Dodd-Frank that still haven't been done. There's Exchange Act and Investment Advisors Act that gives the SEC rulemaking powers over certain areas. It's pretty rare for enforcement to be involved, although sometimes they certainly might be consulted, and sometimes the rulemaking issuing release will, thank various people who might have helped, and you can kind of see what divisions they were with. But it's a pretty separate activity that happens within the commission, and they're doing a lot of it at the moment. So if you have comments, you should definitely submit them. Next slide. So the practical kind of what to do. So what to do when conditions are favorable for an SEC investigation. Tried to word that as neutral as possible. But if there's something where, maybe it was an honest mistake, but it resulted in a reporting error that made it to the filings and you realize you have to restate. No one was necessarily, purposely committing fraud. No one benefited from it, but it happened, and you're going to have to tell the market because you're going to restate. All the way from situations where there is, fraud that was done with intent to we think we have a disgruntled employee and we're not sure if they're going to report, but we think there's no substance to what they say. So there's a whole gamut of things that might give rise to this. Or if a bunch of the members of your board or executive group are all resigning around the same time, maybe it's coincidence, but that's going to raise some eyebrows at the commission. You'll probably get a letter. So what should you do, or what should you at least think about? Obviously, this is all very situation dependent. This is not legal advice, etc. One thing to really consider strongly is independent counsel and empowering your audit committee or creating a special committee to retain their own counsel and have that committee execute the engagement letter with counsel. It is not independent if the company engages the counsel. And the independence consideration, it's really just that it's independent from the company, that it's not your usual corporate counsel where staff could believe that this counsel is reporting to the audit committee or reporting to the special committee and not immediately calling the GC every time something interesting pops up in the investigation, as well as preserve documents. Hopefully you have a good document retention policy anyway, but to the extent you think something's going on, you're going to do an investment, and have an independent investigation, suspend those policies for the relevant people. Just make sure no one's off shredding documents, because odds are a few of those will still exist somewhere and it will not look good when the others do not. And then the consideration of self-reporting. This is a really complex, thing to think about, a lot of different factors. One thing just to note though, it is a one-time opportunity. You do not get self-report credit as part of, if let's say this becomes an action and they're looking at cooperation credit, penalty amounts, all of that. Part of the matrix that staff looks at is, did they self-report? And that is a yes or no answer. Filing an 8K saying you've launched an independent investigation into certain activity is not a self-report. Doing your 8K and then calling the SEC, not a self-report. A self-report is calling the SEC and saying, we have found this issue. We are investigating it. We are going to issue an 8K tomorrow. That is a self-report. And so that opportunity is lost. And maybe it made sense to lose it. And that's something to talk about with your lawyer, but you cannot get it back. And that credit matters quite a lot at the end. And then kind of the other part of that is, or if it's something that you think deserves an internal investigation, but you've decided for various reasons not to self-report, just some thoughts there. Do not officially, in writing anywhere, restrict the bounds of the internal investigation. Like, don't say it's into this specific issue, don't look anywhere else. You can certainly give them a direction and they can mostly only look at that issue, but you don't want to officially say like, and do not talk to, whatever. Draft the final presentation, and this is more for your independent counsel, but their kind of results presentation, what our findings were, draft it or a version of it with the SEC in mind. If the SEC gets a TCR later and they open an investigation and they reach out to you, this could take months. It is very helpful if you have a package to show them that is like, yes, we looked at this, we took it seriously, here's what we did, here's what they found, and here is the evidence supporting that. That is tremendously helpful to everyone. It is an efficient way to handle it. It helps you a lot. There may still be follow-up questions, who knows, but you put yourself in the best position that you can be in, especially said with the documents to support it. It's not just the presentation, it's what supports the conclusions in there. That could, not a guarantee, but it could head off a massive document collection, a search through whole email in inboxes, things like that. Next slide. And so if you receive an SEC subpoena, one, note with your handy dandy method of, is there an M or not? Is it a subpoena or a voluntary request? Is a subpoena actually attached, or does it just sound like a very official request, still with the seal at the top of the letter, but is it not actually a subpoena? Also note that you do not need to stress about the due date. I don't think this is a secret. Generally, I'll say when I send subpoenas, you put the due date like 2 weeks out. That is the sit up and take notice date. It is the please get counsel date. It is please have someone call me date. It is not 100,000 documents will be, in my inbox by that date. So act, but I sometimes have people in a panic, and we don't need to panic. Not about the date. And then you can, if you've received a subpoena, request a copy of the formal order. So that is an internal SEC document. It is a confidential document. But if you receive a subpoena, you are allowed to request a copy of it. It doesn't have a ton of useful information, but it can tell you things like when the investigation was opened. Sometimes it's useful to know if it's been open for a year and they're now subpoenaing you for something, or it just got opened and this is like a first look. It will tell you what charges they believe could have been violated and gives a pretty high level summary of kind of why. Make sure you preserve documents immediately if you haven't yet, and retain counsel. But if you haven't yet and you are handling this internally, immediately have a conversation with the SEC staff. There are lots of ways to narrow the scope of a subpoena, to make it more efficient for you and your company, to roll the production, to highlight certain things that matter more and that might foreclose other of the subpoena asks that maybe won't be needed if certain other things are given. So it is a starting point. It is a preserve all of this point, but let's talk and figure out what would be the most helpful. All right, next slide. And finally, as I've noted throughout this presentation, when you should call your friendly SEC counsel. Everyone, I think, would know a voluntary request letter, a subpoena, a call, any of that, probably want to reach out to counsel. But there are some other times it can be helpful. And one of the things I've enjoyed the most being back in private practice is being added to things, even deals while they're being transacted. Maybe it's an early presentation to a board of director of a newly public company or a SPAC, and kind of talking about procedures, things to keep in mind. There's lots of times prior to an investigation that getting the advice of an SEC kind of defense lawyer can be really helpful. It can be preventative. It can help avoid things in the future. They might be able to highlight things of like, hey, I get why you're doing this, but here's what it looks like, or here's how this could be viewed. And maybe if we word this differently, if we document it differently, if we set this up in a different way, it would look the way you intend for it to. That can be really helpful. I've had some really good calls with some of our corporate lawyers about that. Or if you just have questions, if there's a DOJ probe out there about something that might end up overlapping with you and you want to start thinking about that, or how the SEC might end up involved, or how the different agencies can work together. Questions at the close of an investigation, maybe by a different agency, and you're wondering if the SEC might be involved or not. You're closing a deal like SPACs for a while. They were just really under the microscope, and maybe it's worth, a 30-minute call with your SEC counsel, enforcement defense counsel, of like, hey, how can we make sure if this gets looked at, we're in the best position we can be, that we have done the things that they're going to look at first. diligence being a main one, but that we have, documented this in a helpful way. And again, it's that idea of if someone looks, even if you did everything fine, it can be very expensive to get to that conclusion. So the more you can do in the moment that shows the work you did or the diligence you did, or that you thought about these issues and you answered them, that can be really helpful to then produce in a potential SEC matter, as opposed to them having to go through all of your emails and create that evidence themselves. As well as board of director presentations. I know our corporate attorneys do that fairly often, but sometimes you may be having someone with the SEC experience on the line can be an interesting thing. They can ask questions. The SEC is currently very focused on individual liability and finding paths to it. So kind of talking about that can be a helpful thing. All right, and with exactly 5 minutes left, questions. I was going to plant some and I didn't. So anyone? I think we have to take an hour to get CLE credit. So if you don't have a question, I have to tell you a story or something. Yes.
So when you talk about the self-report credit, so if you launch an internal investigation, at that point it's too late to self-report. You have to report before you do any internal investigating.
That is a great question, and no. So if you do an internal investigation and you yield findings that you think you want to self-report, let's say maybe it's because you yield findings that you're probably going to have to publicly disclose. At that point, you could still self-report. You haven't told the market, you haven't otherwise disclosed it, you followed your own policies. We want companies to investigate things. That would still count. When it doesn't count is when you've told the market, and then later counsel's like, you should call the SEC too and self-report. And SEC's like, thanks, but we also get those filings because you filed them with us. So it's less helpful there. Yeah.
Is there always a formal closing of the investigation, or do any investigations remain hanging?
That is a great question. Investigations should always be closed. MUIs, that can be different. That procedure varies throughout the years, administrations, directors. Sometimes you do get a letter asking for some information and you never hear again. That happens a lot. Generally, that means it closed. An investigation, if you were a subpoenaed party, you should receive an investigation closing notice. You don't always, sometimes there's programmatic reasons they don't want to send them, but you as staff have to explain why on the inside, because the assumption is that you do. They also expire at a certain point because our statute of limitations is pretty strict. If you haven't, that is definitely a question your counsel can ask. Has this been closed? Because the closing memo has to be made. And if you're just from a practical perspective, if you're on the staff, you have these quarterly reviews, and generally they list your cases from oldest to newest. And so all your questions are about the old ones and why haven't you done it? Why isn't it closed? Why haven't you brought it? So they're not going to forget it exists. They have a reason, or they just haven't been able to get to it. But at a certain point, especially under the new administration, old cases are not favored. Yes, and sorry, I just realized I'm supposed to repeat the questions. The priorities of Chair Gensler, they are many. I think the best thing I can point you to are the statements that come out of his office. But I think, he believes in regulation, believes it makes, markets and everything better, that honesty and transparency are helpful, and rulemaking is a way to get there. Seems, are certainly a lot of the priorities of the commission now. Exam has put out new priorities that are pretty detailed. Enforcement kind of gets their own, orders, but all from the chair's office is, I think, using kind of every tool the SEC has to look at anything that is active right now. So your SPACs, ESG, investor activism, investment advisor rules. It's kind of all a priority. At least if you read his statements. Again, I checked all this for make sure it was all public knowledge before I came up here. And he issues pretty frequent statements on the various priorities. It's a very active office. Like 1 minute. Yes.
What is the value of a self-report like the day before you file an 8K? Is it anything other than just to get it out of there?
No, that's a great question. There actually can still be a lot of value, even if it's like the day before, because what a self-report does the value I will say on to the client, to the entity, is that you could direct potentially where your investigation's opened, which office, even which attorney. It's not a guarantee, but you can try. That has a lot of value, especially if there's one that your counsel's worked with and said, they're fair, they're diligent, they're someone who's responsive, all of that. That can be really helpful. So there's that kind of a soft factor. And then as far as actual credit goes, it can be a lot. There's a lot of remediation that a company can do that's important, but there's certain cooperation factors that have to exist to make that remediation really count. So there are plenty of cases, and I had a few at the end that were settlements where they were violations, even fraud violations, that the company did eventually catch. They self-reported, they fixed it, and they worked hard to fix it. And so you're still charging them because it was a real violation, but there wasn't a penalty at all. And without that self-report check mark, it's hard to get to like something like that. It's hard to get to zero. There's still credit for other things. Cooperation, is still a helpful thing, but it's just one of those check marks that you can't get back. And so it's something, to really think about. But not doing it doesn't mean you couldn't still eventually get there. I mean, usually the right answer is the right answer, but it helps in the recommendation process if you can say the company self-reported. All right. Our hour is up. I'm going to mute myself in a moment, but thank you everyone online for joining us, and reach out with any questions. Thanks.